Welcome, everyone, to the Global Congress on Intellectual Property and the Public Interest. My name is Hannibal Travis, and I'm happy to have been invited to give a talk today. My topic is Transnational Interference with Privacy as a Crime Against Humanity, and the subtitle is The Sanctity of the Home and the Security of its Inhabitants' Correspondence. This is a topic that I believe to be especially relevant during these times because we are more and more reliant upon the internet and digital communications and the privacy of those communications to do both our daily work, pursue our careers, and to pursue our personal interests and family and friend connections. And in the past, when societies or individuals have become reliant upon a technology, international law has sometimes stepped in to protect that reliance interest or to ensure its respect for that interest. So, for example, ambulances were introduced in the 19th century to take by horse-drawn carriage, wounded soldiers off the battlefield to medical treatment and so forth. And then international law respected that and stated that it would be unlawful to attack these ambulances; they should be protected. Then, when medical aircraft were introduced, uh, these were also protected. Uh, with changes in technology, there could be a evolution in international law to move from ambulances to medical aircraft. Then international law also evolved to protect nuclear power plants from attack as a new technology that cities and countries relied upon to power their activities and made it unlawful to interfere with or target those essential pieces of infrastructure. And today we have internet communications playing a central role in medical care, in power plants, and throughout the rest of the economy and personal life. We are heavily reliant upon them, and they are protected under international law. And I will describe how we might improve or enhance those protections. Uh, One reason why international communications over the internet are so important these days is the coronavirus pandemic and the projections that unless individuals practice effective social distancing or sometimes even stay strictly at home, there will be an unsustainable number of hospitalizations and the resulting mortality from that. This is just an example from New Orleans. The baseline would be almost 4,000 hospitalizations per day. With effective social distancing, it was less than half of that. With strict shelter in place, it would be 1/4 of that, and it could decline to zero. But how do you shelter at home and maintain your relationships, your business, your career, everything like that over internet communications increasingly? And moving forward to today, the projections in the United States are about 5,000 deaths per week due to the absence of a strict shelter in place order. And really, it's arguably unsustainable. But there are projections it could go as high as 8,000 per week, which would lead to 400,000 or more fatalities in the United States. Internet communications, staying at home, working remotely, help prevent that worst case projection from coming true. In Florida, it was projected that there would be very little additional mortality between May and September. In fact, that did not come to pass. And deaths are, you could see in the orange line, almost at a 45-degree angle, moving upward. So the home is a place of it's always been had a certain sanctity to it, but increasingly today, it's not only an essential public health tool, it is the hub of commerce, of political discourse, and of all other aspects of our life. And the correspondence to and from the home is protected by international human rights law and intellectual property law from interference, interception, and certain chilling effects from state or non-state interference. And there are two forms of interference that I'll really talk about today. One is chilling in terms of stopping or making people afraid to engage in internet communications. And the second is opening, interception, and retention and perusal of these communications. A famous example of the latter are the iCloud and Apple device hacks that result in selfies and the like being leaked to the internet, traumatizing the person who took the selfie. The celebrities are the most famous example of this, but it happens to a number of different people. Also, the Sony hack, the sort of release of private salary and other records, email communications, from the home to the office, or between workers at home, at Sony Pictures, uh, believed to be in retaliation of their plans to release the film The Interview. The WannaCry crypto worm, spreading from computer to computer via Windows vulnerabilities and threatening to actually locking all of the files, rendering somebody's own, uh, perhaps their life's work, inaccessible to them unless they pay a ransom, therefore called ransomware. Um, and in the case of WannaCry, it affected 230,000 computers in the first day. Um, at the National Health Service, the United Kingdom, urgent cancer appointments had to be canceled. Unpatched Windows 7 was often blamed, but it was said that if governments had communicated effectively about vulnerabilities in Windows with Microsoft, the National Health Service, other entities, this could all have been prevented. The attack was ultimately probably not aimed at the NHS, but it shows how worms, Trojans, viruses, other internet contaminants can affect essential health infrastructure and other economic activity, even when that is not the objective of the person. Uh, Other examples of this, we have X-keyscore reports, software residing inside governments that can eavesdrop on everybody everywhere, whether through text communications or voice, or imagery, video. The rise of big data surveillance, private corporations partnering with the government on artificial intelligence solutions that would gather and analyze communications and other data at a massive scale. It's touted as helping solve social problems, but it could be creating other problems, according to scholars, as memorandums of understanding and fusion centers are created that bring together private reservoirs of data with public reservoirs of data, thereby exposing what individuals believe to be their private um, thoughts and words to storage and access at the hands of unknown parties. Also, the breach of these government stores of data is an increasingly large problem. The Office of Personnel Management had all of its background check and other personnel data hacked. It's not known, the extent of harm from that. At least I don't know. It may never be fully known. But people who believed that they were communicating with the government with a certain degree of confidentiality in order to get a job or a promotion ultimately lost, control of their most personal life data. There are failed models for preventing these forms of interference with communications and privacy. I'll just go through a few of them. In the United States, the Federal Trade Commission Act is the source of authority for the government to punish companies who do not respect their own privacy policies or who otherwise operate unfairly with customer data. This is not necessarily working. The jurisdiction over foreign interference with a U.S. person's data is limited. It tends to focus on the U.S. corporation or the multinational corporation that's active in the United States and has operations that can be targeted. It's not necessarily a model for targeting cybercrime that effectively. Also, doesn't necessarily apply to government actions. It's more about commerce. The Computer Fraud and Abuse Act prohibits accessing computers or certain communications without authorization. There are large loopholes within this as well for, number one, government actions, and for number two, actions that are arguably authorized, but sometimes via vague terms of use or data use policies that the customer may not understand and that they may not be enforceable in court, even if the customer does understand them. Trade secrets law, misappropriation of confidential financial or business data is a cause of action in most countries and a crime if it rises to the level of willfulness or economic espionage. This is not if you look at the number of reported cases, for example, in the United States, it's a very small number compared to the number of data breaches, cyber attacks, and so forth. Data protection authorities in non-U.S. jurisdictions are said to be the solution to this, giving individuals the right to access their data, understand what data is being held and processed that concerns them, and delete certain data. It has promise. It is offering a mechanism to create transparency and fairness as to certain data reservoirs, but it has large gaps as well, especially in terms of cybercrime and government penetration of private data. So my sort of thought experiment in this paper is to approach the interference with private communications and the home as a crime against humanity. What do I mean by that? Well, it would give rise to an obligation on the part of states to repress this crime, no matter where it occurs, no longer linking criminal prosecution to the nationality of the defendant or the location of the perpetration, but rather this notion that it's a crime against all the world, it's a non-derogable norm, and that all states should cooperate to repress this violation. Universal jurisdiction, just as with genocide, the slave trade, piracy. And I think there's a good analogy with piracy in the sense that the pirate on the high seas interrupts the peaceful flow of goods and persons from nation to nation and from island to island within nations. Similarly, the cyber attacker interrupts the peaceful flow of speech, interpersonal relationships, religious, cultural, artistic, scientific discourse from nation to nation and within nations. This could give rise to civil claims under the law of nations for countries that recognize international law as part of their law, as the United States, for example, does, and could give rise to restitution or other remedies for the person who's been a victim. There are certain factors that have been developed by international criminal scholars, such as M. Sharif Bassiouni and others, to distinguish crimes against humanity from other crimes that I think are applicable to this form of interference with the home and its communications. Number one, that it's a widely shared norm. For example, the norm against piracy is a widely shared norm. The pirate is an enemy of all humanity. Similarly, we can say that the cyber hacker does something that's wrong in the view of most nations' laws. They obtain unauthorized access. They violate data protection principles. They commit an unfair and a fraudulent action certain times. It's a transnational danger. In the words of Raphael Lemkin, genocide is a transnational danger. It threatens the artistic and scientific contributions that each people would contribute to the global evolution of humanity. In the same way, cyber attacks are a transnational danger. All nations, or most nations, have signed on to the Universal Declaration of Human Rights. It's been around for decades. The International Covenant on Civil and Political Rights, this is the map of states parties to that, according to Wikipedia. All the countries in green are members of that. So that's a widely shared norm. That contains Article 17, the right of privacy in the home and correspondence. And the home, under that provision, is very widely interpreted to include also your common place of business or your professional office, and also to include the correspondence coming in and out of the home or in and out of that office. Also, another factor identified by Bassiouni in making it a crime against humanity is an offense against internationally protected persons. Or sometimes a war crime is a crime against medical personnel, diplomats, UN facilities, UN peacekeepers, not necessarily a crime against humanity, but a war crime. And we've seen examples of world leaders and diplomats, UN diplomats, world leaders like Angela Merkel and Luis Ignacio Lula da Silva having their phones hacked and their communications chilled or intercepted without their permission. And there's also a nexus to other violations of widely shared norms and other transnational dangers, other threats to international peace and security. Many of the persons who are targeted by interception of their data and their communications are human rights defenders or international lawyers or diplomats. And they are acting on behalf of all humanity to prevent other mass atrocities, genocide, war crimes, aggression, slave trade. So you see, for example, in maps of freedom and unfreedom on the internet, some of the places where people are targeted for some of the worst atrocities: Myanmar, the Sudan, the Kurds in Turkey. These are also places where the internet is not secure, either in terms of freedom or privacy. Also, in terms of intellectual property, confidential business data, we are seeing that the losses are estimated in the billions of dollars. Maybe it's not quite what the United States says, 300 to 500 billion of dollars of losses per year, but it's in the billions of dollars. So humanity is losing part of its development, part of its innovation, as a result of the breach of confidential communications. And there is a very noteworthy projection by the Atlantic Council and the Zurich Insurance Company, which issues cybersecurity insurance, I believe, which says that a lack of cybersecurity and a rise of hacking and a deterrence and a chilling effect on internet communications could result in a loss of $90 trillion of cumulative net economic benefit from digital technologies. So humanity itself will be the victim of that scale of a loss. So you would need to carry out this proposal to add cyber attacks to the sort of attacks that are regarded as crimes against humanity when they are directed against a civilian population on a widespread and systematic basis, as I believe some of these forms of interception and chilling are perpetrated. And there are two sort of analogous crimes against humanity: severe deprivation of physical liberty in violation of fundamental rules of international law. Here, this would be a severe deprivation of an intangible liberty or privacy principle in the home in violation of fundamental human rights norms. And there's also a provision for other inhumane acts of a similar character that cause serious injury to bodily or mental health. You might say that acts like iCloud hacking can result in serious trauma. So there's an analogy to that crime against humanity there. There are also war crimes that are analogous: extensive appropriation of property not justified by military necessity or carried out wantonly, or attacking dwellings, which are undefended and are not military objectives. Similarly, cyber attacking dwellings or attacking other civilian facilities with cyber attacks. Now, there are certain challenges in treating cyber attacks and interference with internet communications as a crime against humanity. One is the distinction between war crimes and crimes against humanity. Perhaps this is better treated as a war crime. I would leave that to the negotiators to decide where in the Code of International Crimes to put that. There could also be a form of universal jurisdiction over war crimes, so it may not make that big of a difference. Also, when you are the victim of a cyber attack, unless it's a ransomware attack, oftentimes you remain in continued possession of your property or intellectual property. Somebody merely has a copy. So it's an intangible harm. It's a little bit distinguishable from extensive appropriation of your property in the sense of a war crime, where the army actually kicks you out of your house and you no longer have it, or takes your food or your vehicle. There's a disanalogy there, this intangibility problem. Also, there's the question of lawful and proportionate means. Under international human rights law and under domestic law, a search with a warrant or an exception to a warrant requirement, some proportionate search or surveillance is not a crime. I think there is a way to incorporate this notion within the definition of the crime, just as lawful warfare or counterinsurgency is not a war crime or a crime against humanity. You could say that lawful surveillance that's proportionate and that prevents certain other even worse crimes could be justifiable and not a violation of any international principle. Also, some people would have a defense of duress and necessity. Basically, they work for a government that forces them, like North Korea, for example, to violate other people's privacy, and otherwise they'd be executed or their family would be targeted. This was often said of collaborators of the East German Stasi or other oppressive regimes. Necessity would be the defense for, we're actually invading the privacy of certain communications to expose even worse crimes. Maybe somebody like WikiLeaks could take advantage of this doctrine of necessity. That is the end. I appreciate your attention today, and I look forward to participating in the rest of the Congress, and I hope that you are able to do so as well. Good afternoon.